So let's take a look at child support in Massachusetts. The child support amount comes from a formula. That formula is arrived by plugging in certain numbers into the child support guidelines worksheet. Basically, there's a formula, it goes through, it spits out a number at the bottom. That's the bottom line. That's the amount of child support that will be due. Now, sometimes the question comes up, can a judge deviate from that amount? And the answer is yes. A judge can change the amount of child support in certain circumstances. They do have the discretion to do so. If a judge is going to do so, he or she must put their findings in writing. Among other things, they must put in writing what the original amount would be if the guidelines were followed. They must put that it is unjust or inappropriate for that amount of child support to be ordered. They must be specific on the facts of the case. They must say exactly why it is that they are deviating from the recommended child support amount. And they must put in writing that it is in the best interest of the child. Because everything in the probate and family court system having to do with children in a divorce or in a paternity action, everything is guided by the best interest of the child standard. So everything must come secondary to whatever the judge thinks is in your child or your children's best interest. So if she's going to change that amount, it must be in your child's best interest. Now, why would a judge change the amount or deviate from that amount? Well, there are a number of possible scenarios that a judge can use to change the amount of child support that's due. One of the things is if the parties agree. So if you and your ex agree on a different child support number, you can agree to that number and take it before the judge. Now, the judge still has to approve that number. Just because you're in agreement doesn't mean that that's going to be what the court accepts. But if you have an agreement, you can certainly present that to the judge, and the judge is probably likely to at least entertain the idea and look at the numbers to see if that would be an appropriate amount of child support. Another thing would be if the child has special needs. So if they have any special developmental needs or something along those lines, that can affect the amount of child support that would be due. As you could well understand, some children have a higher need for a certain level of care or certain equipment or something along those lines. So that may well be a reason for changing the child support amount in your particular case. Another thing would be that if a child or one of the parents has an ongoing extraordinary medical, physical, or developmental issue that has financial consequences. That's something that the judge would look to when deciding if indeed they would deviate from the child support guidelines. Another thing would be if the parent has extraordinary health care costs for health care coverage. So if health care is particularly expensive for some reason, like way more than usual. I mean, let's face it, healthcare is very expensive all on its own. But in certain cases, a person, a paying spouse, may have an unusually large amount of money that's going towards healthcare. That would be taken into account as well. If there are extraordinary, easy for me to say, if there are extraordinary travel expenses for the parent, for parenting time, that can be addressed as well. That can be brought up before the judge. So let's say the parent lives far away from you. In order to come back for the parenting time, which the court wants it, would encourage, because they want the child to have a bonding and a relationship with both parents. If they have to pay a great deal of money to come back every time for their visitation or for their parenting time, that amount of money should be perhaps looked at and thought that in a way that you're contributing to your child by paying that money to travel back and forth to see your child. So that's something else that can be brought up before the judge if you're looking to change the amount of child support. Extraordinary child care costs. Again, child care costs, daycare, and so forth are expensive. but sometimes they are extraordinarily expensive. If that's the case with you, you can also bring that before the judge to see if they would entertain the idea of changing the amount. If the split between parenting time is greater than two-third, one-third split. So how it works is the standard parenting time between the custodial and the non-custodial parent is that basically the custodial parent gets the child two-thirds of the time, the non-custodial parent gets the child one-third of the time. It can change depending on your circumstances. So if someone is receiving a great deal, much less than say a third of the time, that could affect the amount of child support that would be due as well. If the paying person, the paying spouse, is incarcerated, if they are in jail, clearly they don't have a source of income, they would not be able to pay much or anything perhaps in child support. That's something that can be brought up before the judge as well. Um, if the child support guidelines amount, if that would put an unusual burden on the paying parent to the extent that they basically could not support themselves financially, that's something the court would entertain as well when looking to see if they would deviate from the amount. If there's a gross disparity between the paying spouse and the non-paying spouse or the recipient spouse, if there's a gross disparity in the standard of living. So let's say that the receiving spouse is basically living high on the hog. They have a great big house where all their expenses are taken care of and so forth. If that's the case, then a child support amount different from the guideline amount could be something that would be in order. Um, if there are, if the child support would adversely impact the reunification of the parent with the child, if say DCF is involved, if there's been a separation of the between the parent and the children as a result of the DCF investigation and involvement, if for some reason the allotted amount of child support would infringe upon the reunification between the parent and the child, that would be something that the judge would look to as well, because the judge generally the courts want to have, as they say, that want the parents and the children to have a good relationship together. If there is, and basically, sort of the last thing is a sort of a catch-all is if the order is unjust, inappropriate, or not in the best interest of the child. So if the judge has some sort of facts or circumstances before them that don't fall into the any of the prior categories, it gives the judge more discretion to take in anything that they feel is relevant on the basis of if it's unjust, inappropriate, or not in the best interest of the children. Also, something to remember is if the payments, as dictated by the child support guidelines, if they are greater than 40% of the payor's income, that is the person paying the child support, if the child support is 40% or more of that person's gross income, there's a presumption that that would be unjust, because that would put too much of a financial burden on the paying spouse, and the court would not want to put that person in that particular situation. So that's sort of the rundown on how you may deviate from the child support guidelines. Courts don't like to deviate if possible. The whole purpose of the child support formula is to give a certain uniformity from case to case to case as far as what the financial obligations are for each party. But the courts recognize that every case is really different, and there are differences that could be brought up before the court. If you're in a situation where you cannot pay your child support, or you think you need more child support, look to these factors, and you might want to bring it before the judge's attention that a deviation from the standard child support guidelines might be in order.